If you can show me in the law that I can, then let's talk. That means you got to get it
In writing.
No. Go through the actual. This is the Code of Criminal Procedure. In here, there are certain provisions with regard to non-disclosures. Who is eligible for them? You have to read it. You got to digest it. You definitely are not. I don't think you're. I can't get away with it.
In this video, Judge Fleischer presides over a series of hearings involving a woman with an old DWI conviction. She is seeking a non-disclosure, or in other words, she's looking to have the record hidden. Judge Fleischer had previously told her he cannot grant it, and that she should consult a lawyer if she disagrees and wants to research a legal remedy. But she is back again, apparently without heeding the judge's advice.
So you have filed a petition for non-disclosure on a DWI.
Yes.
The problem is that, and the way that I read the law, is that non-disclosures are used when someone has done a deferred adjudication, they've successfully completed it, and then they are allowed to, because they've completed successfully, have whatever case they did the deferred on sealed so that the general public cannot see it. You took a conviction on this case. If I remember correctly, you took a straight conviction on this case. So I don't think that you're eligible for a non-disclosure unless you can show me differently.
I mean, it happened like 6 years ago. So, I mean, I thought by the state of Texas, you're allowed to get a non-disclosure, if not expunged, if you only have one offense of a DWI.
No, the law. No. What matters is what happened on your case. The time, the length of how long it was ago, the numerical, the number of how many you have doesn't make a difference as far as whether to grant this non-disclosure or not. So, unless you can show me differently, I just don't think that you're eligible for a non-disclosure. I mean, look, Ms. Wickenhofer, I love to grant non-disclosures because I love to see people trying to better their lives. So if I could, I would, but I can't. I absolutely love it when people try to better themselves. It's great, but you took a straight conviction. I think if I remember correctly, it was like, let me see, I can pull it up here.
I think it was my lawyer's decision, and to me, like, it's my life. So at the end of the day, my lawyer decided on what to do, and I didn't really know.
You can't say that because they go over all the plea paperwork with you. They tell you exactly what's happening. And
well, why would I file for guilty or anything if I don't want it on my record? That's my thing, is I wouldn't file for guilty if I want it.
I mean, I can't really get into your mind about what happened about 5 years ago. I don't know what was going on in your life 5 years ago. All I know is that you pled guilty to this offense. You were sentenced to 4 days in jail with credit for the 2 days that you had. And I
didn't even do days in jail, though. I didn't do any days in jail.
Sorry?
I didn't what you're saying right now is not what happened. So I didn't do.
You got what's in essence called time served, meaning that you walked out of here because you pled guilty and you got a 90-day license suspension. The sentence technically is 4 days in jail. We gave you credit for the 2 days that you did, so you didn't have to do any jail time.
Oh, okay.
The only thing you did was incurred a 90-day license suspension. I even rolled your court costs so you wouldn't owe anything, where normally people pay around $3,500. So we also did that for you. So, but by virtue of the plea, you're not eligible for disclosure.
But I just, to me, that doesn't make any sense. So just because I pled non-consent, or I needed to plead non-consent, to me, like, I don't go out and get into trouble all the time. I'm no criminal. So to me, like, I didn't know those things, and I don't believe that those things were communicated to me, that I had to plea a certain way So that way later down the road, when I'm trying to get it off my record, and it's not even about bettering my life is better than it's ever has been before. It's not about me trying to, it is better. And the fact that I didn't know that, I don't feel like I should be tormented or felt, disciplined because I didn't know exactly how to plead, because I haven't ever been through this before, if that makes sense. I've never been through this before. So to me, I shouldn't be disciplined or held against my will because I didn't know exactly how to plead. I've never done this before, and I don't have guidance on how to plead because I don't know a bunch of criminals just hanging out telling me how to work the courts. So to me, it's kind of messed up because I don't know exactly what to say or when to say it. I just listen to my lawyers at the end of the day, and I still obviously didn't do the right thing. So if you could please understand that circumstance, because obviously I wouldn't have purposely meant to do this to myself by accidentally pleading the wrong thing. Obviously, I meant to plead the right thing so it can come off my record. I'm a teacher at a junior high right now. I'm actually at work now. I have 2 little kids. I'm trying to teach my business, but obviously I just want it to be non-disclosure so I don't have to ever file for this anymore, and it doesn't have to stay with me for the rest of my life. Like, God
Well, you
forgives,
need to
I
understand,
forgive,
though,
other people can forgive.
No,
So
I know that you're upset with the news. But a couple things. Number one, no one forces anyone to plead guilty around here. Everything done around here is with everyone's consent, and you sign plea paperwork to that effect, indicating that you were advised, you agree with it, and you came up here and you voluntarily pled to the case. I understand you now
but why
have
would I
regrets.
do that though? Like,
Well, how am I supposed to know why you did that?
okay, well, I
That's
made a
on you.
mistake, Judge. I made a mistake. I don't know about these things, is what I'm telling you. I don't get in trouble. I don't know what to do. I'm doing what the people tell me to do. And if I would have known that pleading guilty would lead me here, I wouldn't have done it. I did not know. I was unaware
I
and
advise you to the
uninformed.
fact, like everybody, that there's no buyer's remorse. This isn't like Target. When you plead guilty, you can return it because you don't like it. This is a lifetime decision, and every person that comes up here, we ensure that they understand that they are making a lifetime decision. Once you plead guilty, that's it. If you have any issues, you can always go back and talk to the person who represented you. But I'm telling you now that it
That was 6 years
it
ago.
is what it is.
I don't
So
even remember who represented me.
you
Like,
should be able to look it up, and you should be able to find, okay? I will
don't
say
even
this,
know who
though.
it is.
I will say this, that the type of remedy you are seeking, a non-disclosure, even with this type of order that is granted, it seals it from the general public. All agencies will still be able to see this regardless. So if you ever apply to the state to become something, they will be able to see this, right? All this does is it masks it from the general public. So like if you apply for, yeah, well, I'm getting more than what I should, right? But if you have any issues, what you can do is talk to a lawyer. They can
So
advise
it
you
stays on my
properly.
record forever, no matter what, even if I get it disclosed.
Ms. Wickenhofer, I can't give you legal advice, okay? But what I'm willing to do is that if you want, I can give you your money back. And if you want to, I can put this off for a couple days for you to talk to a lawyer if you'd like, to see,
Give me my money back for what?
for the filing fee. You had to pay a $250 filing fee, did you not?
Yeah, I guess that was in the easy expunction thing.
Sure. Oh, well, no, you had it waived, I think. Well, hold on a second. Let me see. You had it waived. She did a waiver, right? So that she didn't pay?
Okay.
Okay, so there's nothing to give back then. Okay. All right. So basically, long and short of it is I can't grant this for you. If you want, I can put it off for a couple days so you can go talk to a lawyer about it. And we can set you off for mid next week if you want. But I'm basically telling you how it's going to go.
I'm just confused though. How come y'all can't expunge DWIs if you only have one. I
can't-
literally
Ms.
researched
Wickenhoffer, I
that.
can't give you legal advice. You need to talk to a lawyer about that.
Oh, okay.
May the state make an argument that
Please.
may assist the defendant.
This is the district attorney on your case.
Okay. So in the government code, chapter 411, subchapter E1, specifically 411.0735, which is a procedure for convictions on certain misdemeanors, the court only has discretion to issue a non-disclosure if they're convicted of cases other than DWIs, among other things. So DWI convictions on a misdemeanor plea are one of those cutouts in the government code in which the judge, even if he wanted to, could not grant a non-disclosure. So because the defendant in this case took a plea of 4 days county jail, which is effectively a time served, the state's opinion is the government code does not allow the court to issue or grant a non-disclosure in this case.
Because I pleaded guilty, but either way, what the judge is saying is that even if it's a non-disclosure, it's still probably applicable to see through other employees, like they're able to see it anyways. So I guess it really doesn't matter. Is that what you're saying, Judge?
Ms. Wickenhoffer, I can't give you legal advice. I can't. As much as I'd like to, I can get in trouble for doing that. So, Mr. Haddad was nice enough to tell you why you're not eligible for it. The only thing I can tell you now is that if you want, you can go talk to a lawyer, and I'm willing to give you a short reset for you to go do that to see if there's something else. But you tell me, what would you like?
That's fine. I guess a reset, and then I'll call them and ask them.
Okay. Tell me what day next week do you want to do this again?
Wait, can we do it at the same time? Like 10:30 through 12? That's 10 to 12. I'm usually off. So
Sure, of course. Tell me what day.
any day, I guess Monday.
Is that enough time for you to go talk to a lawyer?
Yeah, I'm going to call them right now.
Okay.
Yeah.
Remember,
I have
lawyers,
them.
remember, lawyers are really busy, so be patient. Don't expect them to just jump at, just, you know.
It's not a lawyer. It's a expansion people. They're the ones who's working it. Not
Hey,
me.
remember-
Not a lawyer.
Talk to a lawyer. Don't talk to these people who are not lawyers, because they may give you shoddy advice. So be careful who you
Okay.
talk to, you know?
Okay. Yes,
If you
sir.
talk to some Joe Schmo who tells you they know. All right.
What day?
So what, do you want Monday?
Yeah, Monday sounds good. At what
Okay.
time?
All right, done. Same time, noon on Monday.
Okay, sounds good. Thank you.
Yes, ma'am.
The next day,
I have Miss Wickenhoffer here. Remember the non-disclosure from Friday?
Yes.
Yeah, I'm here.
Miss Wickenhoffer, good morning, or I guess good afternoon. So is there anything else that you have found as far as us being able to grant it?
Yeah, I was just gonna say I apologize for last time. I guess our videos were posted on YouTube and I just kind of feel exposed right now. I don't think it was y'all guys, but I got kind of upset about it and all kinds of people were
Look,
just-
there's no need, really. I get, and we all get emotional, we all get upset. It's not a big deal. And I have lawyers here that they get upset. We all get emotional because there's a lot at risk. There's a lot at risk. There's a lot.
Yeah, well, I'm just upset that someone was recording me during this and posted it on YouTube. And there's like, I don't like my business being out there like that. I'm a very private person. And now I just feel kind of,
I mean,
privacy is
I
kinda-
live stream the proceedings so that everybody gets a view of how court works, everywhere. So,
I understand. It's just, I didn't know that. I knew that it was live stream. I just didn't know other people could come in and record it because they have nothing better to do. So that's irritating. But anyways,
what would you
if
like? Go ahead.
No, go ahead.
I have looked at the statute. I don't think that I can grant your non-disclosure.
That's fine.
Had you done a deferred on the DWI, which is typically what non-disclosures are reserved for, we could grant the non-disclosure. But when you take a time served and it ends up as a conviction, that stays there and it's like that for life.
I understand. I thought I did do deferred. I know that my license got taken away for a while but I thought I was actually texting my lawyer and I thought I did do deferred.
No, I wish, look, ma'am, Ms. Wickenhoffer, I wish I could. Because I really like it and I love it when people try to better themselves, but I can't.
I understand. I just need something in writing that tells me why I'm not eligible and something specific. If you could send that to me.
I'm not going to do that. I mean, what I can do is I can just give you the order that says denied, but I mean, I'm not going to give you a reasoning. I'm telling you, you're just not eligible for it. So
I understand, but the people that I'm working with are telling me that I am. So is there any way that your secretary or someone could just jot down reasons as to why I'm not eligible? That way we can get something going on, because I've already told you this, but I've already hired people to work on this case. So I need the reason why, or if you could just tell me why and I'll write it down and I'll send it to them.
Judge, well, I mean, we live streamed, the state gave its position. They could use that.
I mean, I'm not going to.
I just need to know why I'm not eligible. Why? Give me the exact reason so I can write it down.
You pled guilty to the case and you took a conviction. As a result, you're not eligible for the non-disclosure.
So that's it? That's the only reason?
That's it. Yeah, that's it. So, do you have the order for Ms. Steph, do you have the order for Ms. Wickenhoffer? We can put it in the queue. I'm going to put the order in the queue, or they're going to put the order in the queue and I'm going to sign it. Okay. You should be able to get a copy of it off of the district clerk's website within like 2 to 3 days. That way you can also have a copy of it. Okay.
Okay. Yeah. Cause that would help me out. That's why I feel so lost. Cause it's been a while. So I don't even
I
know
wish I
really
had better
what
news
happened
for you,
6
man.
years ago. That's a long time ago. So.
Yeah. Okay. Okay, ma'am.
How can I get it? I just go to the website?
Yeah, just go to hcdistrictclerk.com, put in your cause number, and you should be able to go to the images tab, and then you can print out a copy of it.
Okay. I'm pretty sure they have it. So you said the only reason is because I pled guilty and I took a conviction.
Correct.
And I didn't take deferred. I'm going to ask my lawyer because I don't have it in writing, but she should know. And then
You can also, when you go to the district clerk's website, you can also pull a copy of the judgment as well. All that's there it's public record. So you can pull all those documents there from the district clerk's website and you can see what you did. So it's right there in black and white. So it's everything's there for you.
okay.
So that you can see it, a copy of the information, the charging document, the plea paperwork, it's all on there for you to see.
Okay. All right. Appreciate it.
Yes, ma'am.
Thanks. Have a good day. Bye-bye.
Take care.
Several months later.
You have a cause number by chance? Okay, what is it?
Is 22
Okay,
24
okay.
574.
Ms. Wickenhoffer, in the flesh.
I know, right? We're famous, by the way. Over 30K people watch it. Anyways, it doesn't matter. I have to read off my phone, so I apologize, but
It's okay.
it says, Your Honor, I was convicted of driving while intoxicated in this court on October 14, 2019, under cause number 222. You already got it. I was sentenced to 4 days in jail, and I have completed that sentence, including paying all fines, costs, and restitutions. I am here today because I meet all the legal requirements under the Texas law for non-disclosure of this conviction. Specifically, number one, my conviction was for DWI with a blood alcohol level below 0.15, which actually was 0.11. I specifically remember. I was not placed on community supervision for this offense. This offense did not involve an accident with another person. I finished my sentence over 5 years ago. I have not been convicted or placed on deferred adjudication for any other crime except for minor traffic violations.
This conviction from 6 years ago is still hurting my reputation and my ability to grow in my career. I deeply regret my actions and have learned from my mistakes. Since then, I have worked hard to turn my life around, and I'm asking for a second chance. Granting this non-disclosure will allow me to fully move forward, both personally and professionally. It would help me reach my potential and improve my future. Thank you.
Absolutely. So I don't think I can. Show me where you think I can, but non-disclosures are traditionally for people who take deferreds, complete the deferreds, and are eligible to have it sealed. Expunctions are for those that meet the requirements where if a case gets dismissed, they can have it expunged. Here, when you plead guilty, I don't think you're eligible for either. And the thing about it, I can't give you legal advice. I can't tell you how to look this, how to look that. But if you have a piece, or if you can show me the law that says I can give you a non-disclosure, and I can tell you, Ms. Wickenhofer, I love it, and I've told you this before, I love it when people try to better themselves, right? If I can, I will, because I'm always about trying to make someone's life better, right?
Yes, sir.
But I have to follow the law. I can't just say, okay, I can't just rubber stamp and do it just for the sake of doing it. There has to be a law, because if not, they appeal it and I'll get overturned.
Yeah, I think it,
That's
yeah,
what
I think it was
traditionally
the
happens.
points I said, because I was under a certain amount of alcohol in my system.
That doesn't, what matters is the ultimate result in the case. Did you plead guilty? Did you do a probation? Did you do a deferred? I think that the legislature even now made deferreds available for certain types of DWIs so that people don't get convictions,
I
right?
understand.
But, we never do them, right? But you can, right? And it's surprising that no people do deferreds on DWIs.
Traditionally in Harris County, Judge, we don't even offer deferreds on DWIs.
But if theoretically, if you go without an agreed recommendation, we could, and I think that we may have. I don't remember, but
So they don't
have to-
grant deferred here then in Harris County.
no, you can. It's
You have to pay more money, so it sounds like.
no, it's not about money. It's about, there are other options that are better
Okay.
for some. So
I think that's probably why I didn't do it, because they didn't give me the option to.
we always do, though. Every single case. I talk to every single person that comes up here, and I make sure, hey, look, you're making a lifetime decision. Are you sure that you want to do this? Because it's not Target. You can't return it once you do it.
Yeah.
I literally, every person I scrutinize, micromanage. That's why we're still here. It's 110 when most judges are gone by
I
now, right?
understand. Yeah. People tell me.
I really care about everybody that rolls here, and I want everybody to get the great result. And I don't know what was happening in your life at the time when this happened. Why did it end up like this? Was there something other? Did you have other charges elsewhere? If you can show me in the law that I can, then let's talk. That means you got to get it,
In writing.
No. Go through the actual, this is the Code of Criminal Procedure. In here, there are certain provisions with regard to non-disclosures, who is eligible for them. You have to read it, you got to digest it. You definitely are not, I don't think I can't give you legal advice, right?
Yeah, I understand. It's something we could do, but I don't know. I just want something to be done. I just don't know what can be done. It doesn't sound like anything, which really sucks for me, but.
Nice. Yeah, and then the thing is that I even tell people that, within a certain amount of time, if you get buyer's remorse, within 30 days of doing something, we've really reopened cases for people who get buyer's remorse. But here, the case is 5 years old. I have no jurisdiction. Even if I wanted to reopen it to do something, I can't. The only advice.
Any service I can do, like any extra thing I can do.
What I would do is really go to a lawyer you're going to have to spend a little bit of money, go to a lawyer and fine tooth comb non-disclosure law
Okay.
and see, is there an out? Is there this? Is there that?
Mm-hmm. Just ask questions. Okay.
You may have to like hire a lawyer to really dig into it to see what you can do. Okay. But I can't give you legal advice. I can't sit there and comb the code with you to see, is there a provision that would get it? Because there's so many little nuances here and there. Right. I mean, even so much as a 0.15 or above or 0.15 or below, how long it'll suspend your license versus this, versus there's just so many little nuances. I'm so sorry.
It's okay. What was that book called again?
The Code of Criminal Procedure.
Okay. All right.
So,
Thank you.
and right, Google Code of Criminal Procedure, Texas non-disclosure, and even if you do that in Google, you'll have so many other lawyers' sites. Read through all those.
Okay.
But I don't think that I can. Once you plead guilty, that's it. That's why I caution everybody, when you take the easy way out, when you do something like this, it's a lifetime thing.
Yeah, I understand. Thank you.
Sorry, Ms. Wickenoff.
Mr. Davis.
Yes, Your
All right. So here's the thing. Whatever agreement you all are able to come up with, that's whatever agreement you all are able to come up with. Now, I understand that sometimes people will look at cases differently. And when they look at them, they think it's the range of punishment is something else. But then when they discover that there are enhancements involved, then your range of punishment increases. So on each of these cases, they are proceeding on you as a habitual. So normally where your range of punishment may be at a state jail level, it is not when you're being habitualized.
Yes, ma'am.
Now, when it's a habitual in the count, for example, this unauthorized use of a vehicle, normally that's a state jail felony, 180 days, up to 2 years in the state jail facility, and up to a $10,000 fine. That's normally what the range of punishment is. But Texas has enacted through the legislature that if somebody has been to prison before or has previous felony convictions, their range of punishment can be enhanced. What does that mean? That means that even though technically and legally it's a state jail felony, you're not at state jail felony punishment. Do you understand?
I understand it totally, Your Honor.
So here's the thing. The state has made an offer. Do you know what the state's offer is? That's either yes or no.
Yes, ma'am.
All right, state, your offer that you have made to Mr. Davis, is that your final offer?
Yes, Judge.
All right, so just 1 second. State, do you have any plans on changing whatever offer you made to him?
No, Judge.
All right, so they're saying that their offer won't be changed. So whatever offer they made you, that is the offer. Yes.
Okay, I'm just trying to get something straight because last time I got 2 6s concurrent. I signed 2 6s concurrent, but I picked up a case after the first one. I did 6 years, 10.5 months flat.
Mhm.
Right? So they're offering me a 4. Right?
No, I don't want to know what they're offering you.
Well, I got 2 charges. I just got this other charge. I've had the first charge since September, right?
So what are you saying? You don't think you're?
I got 2. They won't give me my back time when I get to TDC.
Well, let me just tell you.
So
they're
I'll do
not-
4 years,
Let me
9.5
just tell
months.
you, they are not in charge of whether you get your back time or not. I'm in charge of that. And what I can tell you is put on your listening ears. Take a deep breath. All right, take another deep breath. This is what I want you to hear. If these cases were pending and you were not on bond for these cases, right? If they're pending and there's a warrant out for you on these cases and you didn't make bond on these cases and you're sitting in custody, you receive credit for that. That's the way credit goes. And legally, that's what you're entitled to. Now, somebody else will calculate your time. I'm not in charge of calculating your time. What ends up happening is I just will tell you, you get credit for any time served that you have been in custody on these cases. Then the clerks will calculate that time. If you believe that time is incorrect, there is a legal process where somebody else will look at it to see if it is correct. And if they say it's correct, then it's correct.
I understand everything you're saying. I mean, it's totally 100% correct. But when I get down there, they're going to start from my most recent one. So that's only 2 months back time. I got 8 months back time, 9 months back time on the other one. I'm not going to see any of that. I'm going to end up doing 4 years.
Well, so this is
4.5 months.
I don't think you're hearing me. So this is what I want you to understand.
They can't give me that back time.
I'm not in charge of that. The state is not in charge of giving you your time. They can't say, I'm giving you this time. I legally will pass a sentence on you're getting credit for time that you've been in custody. When you go back to prison, if that's what agreement you worked out with the state, then the prison authorities are going to give you whatever time they deem you're supposed to get. If you don't think it's correct, what you're going to end up doing, an attorney may do it or you may do it, you're going to file a motion saying, I'm not getting appropriate credit. Then what will end up happening, it'll come back to the powers that will be, which will be this court, and I will receive notice from admin saying, we've recalculated the time is correct, or either they're going to say, the time is incorrect and this is how much time you should have. And if they come back to me and say, this is the time that you should have, I will sign it and it will go to the prison authorities and they will give you that time. That's how that works.
I understand that. But I just got indicted yesterday on the most recent charge. I mean, I had time to even look at discovery, but I haven't been able to discuss discovery or any case of defense against any of my cases. And yesterday was the second time
You're here.
I was ever offered anything the second
Here's
time,
the thing.
Your Honor.
You're here. He's here. Look at the file.
I need, I want to go to trial, but I can't. With
Okay.
him, I can't. He will not fight for me. I believe he's not going to fight for me. I need proper counsel, Your Honor. I asked yesterday. We've already. I'm trying to talk without cussing and getting.
No, you can go ahead.
Because like this is my life, right? And if I take it to trial, I'm facing 5 to 99. I know that I've already had affidavits put in. He won't turn me in. Right.
All right. So let me explain to you something about affidavits and the filing of affidavits. If these are affidavits from laypersons, that's not how it works at trial. They have to come in and testify.
Yeah, they're willing to do it.
All right. So then what will end up happening? Here's the thing. If you want to go to trial, guess what? In this court, you will get your jury trial. The jury will, if the jury find you not guilty, then they find you not guilty. If they find you guilty, you've already told me you're looking at 5 to 99 years or life in prison.
I'm not, but I don't have adequate counsel to go to trial.
All right. So this is what I want you to do. I want you to sit with your attorney and I want you all to go over the state's file. And this is what I'm going to tell both parties. Using profanity and anger is a sign of people not being intelligent.
Yes, ma'am.
So everyone should treat everyone with respect. I don't care who you are, what you do for a living. So you both are going to go over there, okay? And then if there's an issue, Mr. Hyde, do you still wish to represent him? That's either yes or no.
Yes.
All right, then have you been going over the documents with him?
I gave him a police report of the latest case yesterday. I was just wanting to check that that was enough that you said he's talking about.
All right, so this is what I want you all to do. Sit over there, talk to each other, and then you can come back and talk to me. And if y'all cannot talk to each other civilly, then I'll go somewhere else. All right?
Okay.
So go over there, talk to each other civilly. The last time you were here, and I'd like for people to feel as though, and not actually just feel as though, but to have had a chance to speak to the court, and it appeared that you wanted to speak to me.
Yes, I did.
All right, and what did you want to speak to me about?
Yeah, I have a second to breathe. I kind of got worked up a little bit.
I'm sorry, what?
Can I have a second to breathe? I kind of
Sure.
worked up a little bit. Just pertaining the case, and I know when you went over it, you seen that the protective order was violated multiple times. It's not. I know it. If you read police reports or a person's victim's testimony of what happened, sometimes it could, it's up to the court, your discretion to see if, try to make sense of it, I guess. But when it comes to broadly protective order, we have children together, and to be honest, like I never been in any trouble before in my life pertaining like legal system and having to no contact, like the contact order with my children. And I was a sole provider for my children. Like she was a stay-at-home mother. And when I went back home, like the no contact order, I went back home, but I was the only person on the lease and I didn't have anywhere else to go. And honestly, from what we talked about pertaining me and her, we were fine on good terms, etc. So to be honest, I didn't think it was gonna be any more.
But see, here's the thing about it is that there's an offense against you for choking, right? And when you think about it, choking a person, that means you're face to face with them. They can't breathe and you're still choking them. Now you have that. So you have to know that there's a no contact order in place. And when you're saying, oh, well, I leased the apartment or the house or whatever, that's why I was going back there. Okay, I understand that. But when you were placed in custody at the jail, both parties agreed, your attorney agreed and the state agreed that you were actually contacting her from the jail. And so the thing about it is, you already have this violent offense for choking someone. And then on top of that, you are continuing to contact them from the jail. You had to know you couldn't contact people from the jail. And that just shows the court that you can't follow rules. And she has, according to the testimony that is taken, she left town and is no longer in Texas or wherever she may be. Then, it is what it is. She left town. Maybe she left because maybe she's thinking, I leave town, he doesn't know where I am, then he can stop contacting me. But that's where we are.
Yes.
Sure.
Okay.
See, I don't know how much I say before.
Well, you're not under oath.
Oh, okay. Well, I could speak freely. Yes. Your Honor, he came back and forth to see me unannounced, came to the house unannounced. When she was in a woman's home in Fredericksburg, she was they kicked her out of the woman's home, and the police had to come or whatever to escort her away. She came to the house on February 4th or 5th, unannounced, midnight, because I wasn't speaking to her because we were talking during the protective order. We have children. I was sending money for my children, or she would bring the children so we could see them. We would eat together.
Right, so here's my question. Were you sending money to the children from the jail? That's a no.
No.
But you were still calling her from the jail, and that had nothing to do with anything. So here's the thing. I wanted to hear you out because I know I didn't get a chance to fully explain to you why I didn't grant you probation. But the reason why I didn't grant you probation is because you have a crime where you choke her. And then after you choke her, you continue to contact her. What I'm letting you know is I understand, okay, you're on the lease, you go to the apartment or to the home because you're on the lease and you're trying to make sure that the children have food or have money. That's fine. But then you proceed to call her on numerous times from the Bexar County Jail. That's a no. And for the court, part of the reason why I didn't grant you probation is because based upon your actions, you're telling me you can't follow conditions of probation. So that is why.
I Your Honor, if possible, because before this happened, I was enlisted actively in the military. I was enrolled into medical school for LMRT classes to become a radiologist. And my class started in March 2025. I've been in and out of, grew up in the jail, etc., house arrest, etc. since then. I understand exactly where you coming from and how it could seem to the court, or even like the charge, or etc. I've been sitting in jail and dealing with different health reasons, low potassium and low liver enzymes since the date of my arrest, December 5th to March 18th. I was admitted to the hospital. I had lost 110 pounds because I wouldn't eat because I had psoriasis, which is like my skin breaks out from certain foods, meat, dairy, etc., sugars, heavy. I grew up in a family with my immediate household was my father, my brother, and myself. Out of us three, both of them are felons, and neither one of them graduated high school. I'm the only one who graduated high school. I'm the only one who wasn't a felon. So applying for the probation and adjudication was trying to save me from becoming a felon. I took pride in not having any criminal history. If you could so grant me, I don't have obviously lawyer here, but I was thinking
You can always come back with your attorney. I tell you what, I'll have you come back with your attorney. If you want to come back with an attorney, you can.
No, I'm just speaking to you. I mean, it's up to you. I mean, I just don't want to be a strain on my family, and being that I know that I would abide to any probation adjudication, especially the first. I can try to save my record, save me to be able to go on and have a career in any field or even enlisted army still. I would say if you could maybe think or ponder on doubling the sentence to 8 years probation deferred and double the fines. And if you could possibly consider a no harmful contact, because Carissa has my children and Carissa has my children, she has my car, she has a bunch of my possessions. From our family, both of our families know each other. I knew Carissa since I was 14 years old. Both of our families know each other. Carissa doesn't, she's left her family.
Let me just tell you this. What I would suggest to you is speak to your attorney. The reason why I had you brought back is because I felt that there is something you wanted to say. And I know I didn't get a chance to explain to you why I made the ruling I made. And I will tell you, we're always taught as judges never to explain our rulings, just make the ruling and move on. But I don't like to do that because I don't want people to think that I haven't heard their story, or I'm not paying attention to them, or that I'm not looking at them as individuals. So I noticed as you were being taken away, you were raising your hand. And that made me realize that I really didn't get a chance to explain to you why I ruled the way I ruled. Now, if you're asking or wanting me to perhaps do some type of different sentence, and for me to consider that, then your attorney will need to file a specific motion for that. The coordinator will let your attorney know, and we'll go from there. Okay?
May I say something?
Sure.
I was told yesterday that my lawyer or attorney made motions for reconsideration and a bunch of other motions.
I haven't received those.
That's what I was told from my family when I called them. Before I went up here, this is all off the record.
Yeah, we're off the record. The court reporter is not taking anything down.
I didn't understand what I signed with the silent.
All right, so here's the thing. You need to talk to your attorney about that. So everything else that you're about to say now, you need to talk to your attorney. Your attorney can file whatever motion she chooses to file, okay?
No, I was getting to what I
No,
was.
you're getting to places that
I
you
was
should not
stop
get
there.
to.
I was stop there, but I'm saying that before we came up here, I was told several times that I could be able to.
No. Here's the thing. You are now trying to, or well, attempting to wade into legal matters. And I think you should have your attorney here to discuss that. All right? So, Ms. Ferguson,
Yes.
has a motion been filed by his attorney?
I need to double check that. Judge, do you have his case number, Judge?
No.
They're right.
Okay. All right. And if they have filed, if she has filed something, we'll put it on a docket for it to be heard, and Ms. Ferguson will set it. So just have a seat, and Ms. Ferguson, if she finds something, we'll set it. All right? Okay. So when are we available to hear whatever motion she has filed?
I can do it the first week of June. I need to contact Anita to make sure she's available.
All right. So as soon as your attorney is available before 30 days, we'll hear her. Okay? And if you have some type of food intolerance, you need to let the jail know. If you let the jail know, they will prepare you a specific meal.
I literally, this is all in the notes. This is all the thing I told, when I had a Zoom port for the protective order hearing, I would go to Zoom port in jail, and I told,
Deputy Mejia,
yes, sir.
will you please let the jail know that he has food intolerance to dairy?
Yes, sir. No, it's not just dairy, it's meats, processed foods.
All right, he can't eat any processed food. Will you let them know that he needs to eat green? Yes.
Your Honor, he needs to submit a sick call so they can verify he does eat, that he's allergic and can't tolerate that.
Your Honor, I can tell you exactly what happened. I was in jail for 34 days.
So here's the thing. The only question that I need to know is, did you submit what form?
It's a lot of medical blood work. I took
Did
a lot
you
of.
submit it?
I've been in and out of. Yes, I went to
No,
the
my
hospital.
question is, did you submit the form to the
Yes.
proper people?
Yes, several times.
All right, so Deputy Laura, if you can make sure that the jail has the information on him, and I will send an email.
And I didn't eat until I went to the hospital after 30.
I will send them an email about your intolerance. Is there anything else?
That's it.
All right, so I'm going to send an email right now about your food intolerance. So what specifically can you not eat?
I was wanting to just get some type of fruit, and they didn't give me any fruit. They said because it's hooch and all this.
Okay,
other
this is
stuff.
what I want I want you to listen to me and internalize what I'm saying. As my grandmother would always say, it's not about who shot John right now. So somebody did something or they didn't do something. I'm not at that point right now. Where I am is you're telling me you have a problem. I'm trying to solve it. So I don't need to know the backstory. I'm just trying to figure out, what are you not allowed to eat? What can you eat? And I will send an email to the sheriff letting him know that you are not allowed to eat dairy. So other than dairy, what else can you not eat?
Meats, processed food. I just really fruits and vegetables.
All right. So you're not allowed to eat meats or processed food. And what are the results if you eat meats or processed food?
I have skin breakouts in my face and hair area, etc. And it gets like red irritants with psoriasis.
All right.
I didn't mean to agitate.
No, I mean, I just want you to tell me, what can you not eat? The fact that somebody is still serving you specific things, I'm trying to solve that problem, but I need to know what you can't eat. So you're telling me no dairy, no meat or processed foods, correct?
Yes.
All right. All right, thank you.
Thank you.
Mr. Ross, this one.
All right, the court is calling 2019 CR 12495 State versus Tamar McIntyre. Could I have parties announced?
State, Your Honor.
John Hunter for Mr. McIntyre, Your Honor.
Are you Mr. McIntyre?
Yes, ma'am.
All right, State defense has filed a motion for new trial. Have you had a chance to review that?
I did review.
And are you ready to proceed on it? All right, so the court has read the motion for new trial. I think the motion for new trial clearly has the defense's arguments in it. So with regards to number one,
Yes, Your Honor.
any rebuttal?
Yes, Your Honor. And that, I believe that's the NCIC, TCIC argument, I guess, of the offense. Our position is that we did make it available during court proceedings, and they had access to the actual TCIC, NCICs. And through our understanding of the policy is that we can't allow them to duplicate or keep or make copies of, and that's by, I believe, state orders on that. So that's our position on that front.
All right.
Megan Dowling for the state. Just briefly, if I could address that point, and I want to reiterate the arguments that I made at trial, which is that 411.083 of the Texas Government Code is what governs the dissemination of the criminal histories. They were provided to Mr. Hunter, and that's stipulated to in the motion. He states that the state did provide him those. And so that is our position. It would have been a violation of law to allow him to keep them or to reproduce.
All right. And then defense, because it's your motion for new trial, I'll give you the final response with regards to the state's answer to defense's number one.
Yes, Your Honor, and forgive me. I did not prepare to proceed today. I came to court because the law requires me to show you the motion within 10 days.
Yes.
And so I haven't, I wasn't anticipating actually discussing the merits of it today, but if the court wishes us to proceed with that, I mean, our position with respect to the NCIC argument is fairly simple. We cited you case law, which the courts have addressed this subject matter before and have recognized that it is covered by the Michael Morton Act and that it would be required to be produced. As a practical matter.
Well, you're saying produced, but the state is saying that they did produce it. They just didn't allow you to copy it or leave with it.
It was given to us on the first day of the trial. And in the process of trying to make use of it and note it down, we got into an argument about whether or not we'd be able to photocopy it, which we immediately brought to the court's attention. We had an argument in which the court concluded that we were not entitled to copies of it, which we
does the law say? Does the law say that you are allowed to make copies?
I believe that that is what those cases that we have cited for stands for that proposition, that it is producible under the Michael Morton Act in all ways that other discovery is producible. The state's contention that there is a statute that privileges it from disclosure, I think, is being misinterpreted.
Okay, they're not saying, and correct me if I'm wrong, they're not saying that it doesn't prohibit them from disclosure. They're saying, yes, we do disclose it to you, but you're not allowed to copy it or leave the courtroom with it. Am I misinterpreting what's being said?
That is their argument. Yes.
All right. So
we just disagree with that position. I don't think the law supports it. And we also would maintain, as we maintained at the trial, that as a consequence of, well, let me rephrase that. To the extent that there is any countervailing or overarching privilege that would run afoul of the case law that we've cited, Your Honor, about its discoverability, or that would limit our ability to use it from how we would otherwise be entitled to use discovery. I would maintain that that privilege is waived by two separate independent actions. The first is this isn't a situation where we're trying to snoop on these people's lives outside of the context of defending Mr. McIntyre. He is indicted. The state made that decision. When the state or the government have a privileged interest in the privacy of certain sensitive information, and they elect to indict someone for a criminal offense over it, then they can't be in the position of being able to still hold on to that privilege. They waive it. Secondarily, they have run the TCIC and CIC for these individuals, which is the triggering event. The database is curated not by this office. It's curated by the Texas Department of Public Safety and the FBI. they query that database. They are only allowed to query that database if they have a good faith reason to do so in the execution of their duties and responsibilities as members of the district attorney's office. They can't just go pull NCIC, TCIC on you or me because they're upset with us or they for a petty
You're
difference.
saying that they were upset with somebody, that's why they.
No, I'm giving this as an example. I have had cases in the past where I have defended policemen who were accused of improperly querying the TCIC, NCIC database for petty reasons.
So we're not saying that any NCIC, TCIC was queried without a good faith basis.
No. In fact, quite the opposite. We know that there was a good faith basis because this is the TCIC, NCIC for their witnesses. And Brady versus Maryland, and every case that has come since it says that they have to give me that information. That
Okay,
is a
so
requirement.
then
So-
the main argument, and so let's stick with what the argument is. And if I'm wrong in interpreting what's being said by both parties, the argument is not that you received the information. Your sole basis is that you should have been allowed to photograph or reproduce or take the item, the NCIC, TCIC with you.
We
Is
wanted,
that your?
we wanted to be able to use it in every single way that you can use.
No.
the
My
paper.
question, I'm trying to get to specifics. The specific is,
The
well,
specific,
let me start with this. Number one, was the NCIC, TCIC provided to you? Yes or no?
it was handed to me and I had about 10 minutes with it before we had to turn it back over.
Okay, so now with regards to it being handed to you, then it was handed to you. The next question is your sole objection or request for a motion for new trial with regards to point one is that you were not allowed to photograph it or take it with you. Am I correct in that?
The contention is twofold. The first problem is that we were not allowed to photograph it, take it with us, duplicate it in any way. We had to turn it back over. And as we explain in our second argument, that became an acutely problematic issue because we were unable to make use of that information to respond to the state's argument that for authenticity reasons, we were not entitled to offer Joanna Reyes's prior judgment of conviction at sentencing.
All right, so let's start with this point. First point, state, when was the NCIC, TCIC given to defense?
Prior to jury selection, Your Honor.
And the prior to jury selection, was this the NCIC, TCIC that was given to the defense prior to the jury selection? Do you remember which witnesses those would have been?
It was for all witnesses listed in the discovery.
So would that all also have included Joanna Reyes?
That's correct, Your Honor.
So you're saying that was given prior to jury selection?
It was, Your Honor.
All right. So it's the court's understanding that for purposes of cross-examination, NCIC, TCIC are considered timely if they're given before cross-examination. But my understanding is that the state gave it to you prior to jury selection. So the first question is, were the NCICs, TCIC given to the defense prior to jury selection?
A stack of paper was handed to me.
No, my question is,
I want to make sure the record is clear.
I want
because
the record to
first
be
question
clear
is
too.
not accurate. I mean,
I want to know, they're saying that they gave the NCIC, TCIC of all witnesses to you before jury selection. And it seems your main complaint in here is regarding Joanna Reyes. So my question for the defense is whether or not the NCIC, TCIC, for all the state's witnesses, were they given to you prior to jury selection? Then we can handle your other point.
the word given is not a word that I can address in that.
Were they handed to you?
I held them in my hand for a few minutes. I didn't have an opportunity to digest their contents fully. I wasn't allowed to copy them. Almost immediately afterwards, I was told that their position was going to be that I wasn't going to be allowed to copy them. I had to instruct my
Okay, so
staff.
here's the thing.
Let me just finish real quick.
No.
You know what?
No,
I need to-
because
I
no,
need to
stop. We're taking it one point at a time. My first question is, were they given to you prior to jury selection? It seems that your answer to that is yes. Then we'll get into what you were not able to do with them. So the record is clear. My understanding from you is that witnesses who are going to testify in the state's case in chief, their NCIC, TCIC was given to you prior to jury selection. Now that that's been established, then the next question becomes, what were you able to do with the NCIC, TCIC that was given to you?
Nothing.
All right. So you said, were you allowed to elect, because in your motion, you say you were not allowed to electronically duplicate. Were you allowed to electronically duplicate them?
No.
Were you allowed to copy them?
No.
Were you allowed to photograph them?
No.
And I'm taking that straight from your motion. So state, with regards to the NCIC, TCIC that was handed over to the defense, you're saying it was all of your witnesses in the case in chief.
Yes, Your Honor.
The defense is saying they were not allowed to electronically duplicate, copy, or photograph any of the NCICs, TCICs. Now, why were you not allowing the defense to either electronically duplicate, copy, or photograph the NCIC, TCIC?
Because I didn't want to be charged with a misdemeanor offense.
All right. And where are you obtaining that from, the fact that you would be charged?
Your Honor, I previously stated there are two subsections of law that govern the dissemination of criminal histories. The first being Title 28, Part 20 of the Code of the Federal Regulations, and then the second being 411.083 of the Texas Government Code.
All right. So the state is saying that they could not allow you to electronically duplicate, copy, or photograph based upon Title 28 of the Federal Code and also Chapter 4 of the Government Code. What is your response?
Several things. First, we do not believe that those provisions prohibit a defense lawyer from taking possession of the criminal histories for the purposes of defending a man at trial. That is not the purpose of those laws. That is our position. Secondly.
All right, let me just stop you for a moment. When you say taking possession of it, what do you mean by it doesn't prohibit you from taking possession? What is your definition of taking possession of the NCIC, TCIC, as you see it?
A lawyer should be able to keep the paper with him for the course of the trial so that it can be read, it can be understood, and it can be researched further.
All
and
right.
None of those things were able to be accomplished. I was unable to finish reading the histories. I was unable to digest their contents or understand them or make any meaningful use of them. I was unable to copy them so that I could do that when we weren't in court at recess at any point.
All right. So when you say taking possession, you mean keeping the paper. And when you say keeping the paper, for the record, we're talking about the NCIC, TCIC. When you say keeping the paper, do you mean leaving the courtroom with the paper?
I mean, right. I could not leave the courtroom with the paper. I could not photocopy the paper. I could not make use of the paper. And we had to give it back at the end of the day or at some point during the process. I wasn't able to read or digest the information while I was participating in my other roles as being Mr. McIntyre's lawyer. Counsel said it was handed prior to jury selection. That sounds right. I don't have independent recollection of the day, but we were involved in jury selection for all day and into the evening. It was a lengthy process, and so there was not an opportunity to make any use of it. Also, I can just say, Your Honor, in both federal and state trials that I have participated in, I have never had this issue come up before. I have had prosecutors with the Department of Justice hand me the Jenks material, which would include the criminal history material, prior to the commencement of trial. I understand that the Jenks Act similarly narrows that compulsory moment of disclosure to when the witness is passed for cross-examination, but almost every judge in the United States has recognized that while that law may be that that's when it must be produced, that isn't a fair system. It doesn't provide for meaningful cross-examination. of
Okay, then
witnesses.
somebody needs to change the law. And counsel, I'm sure as you're aware, sometimes people do things that are inappropriate legally, but they do them and nobody ends up saying anything. Nobody ends up charging anybody within anything. But in this court, I'm just here, Mr. McIntyre, to listen to arguments and follow the law. That's my role here as far as this case is concerned, because the jury trial is the parties that made the decision.
But Your Honor, what I'm saying is I don't think that the law has to be changed because I don't think that the law comes to this conclusion. I think that the conclusion the state's asking you to draw from it is not what the law means in its full synthesis, and that the court's responsibility is to allow the lawyers to be able to provide a meaningful defense to the defendant, which includes having access to the impeachment material that is involved in the case. And in particular, Your Honor, what I think we also need to draw clearly is that this isn't just about the general frustration, although there is that general frustration of not having the ability to use that information and have it on counsel table's desk at the exact time that we are in cross-examination or preparing the evening before with that information. Those things all occurred. And so there is a global harm there. But the specific and acute harm, and the reason why a new trial should be granted in this case, is because, as ground two establishes, we have a situation here where the prosecution has misrepresented the criminal history of its most important witness and did nothing to correct that record, even though the very documents we are talking about here, the TCIC, NCIC records, are the proof that it was a misrepresentation. And so that's what really ties this thing together, is that the TCIC, NCIC is being used as both a shield and a sword against the defense. And that's not its purpose. That's the bigger overarching issue here. And certainly with respect to both constitutional law, as it pertains to what due process of law for a criminal defendant means, and in terms of the full synthesis of why these laws exist and what their purpose is and how those things are supposed to operate, it simply is not the case that the court could not authorize the defense to have access to that information during the proceedings. And we were amenable then, we told the court we were amenable then, that we would have taken it under protective order. But that option was not explored.
All right. So with regards to the defense request for a motion for new trial under point 1, that will be denied. Point 2, misstatements of the prosecution in closing argument. What misstatements?
The the state in closing argument told the jury that Joanna Reyes should be credited with belief because she had abided by the conditions of her bail on her tampering case, on her capital murder case, and had not done anything illegal, had not broken the law. And we quote the argument verbatim in the motion. We approached and explained that's just simply not true. Joanna Reyes, after she was charged in Mr. McIntyre's case, and after she entered her plea of guilty to tampering with evidence, and after her sentencing was held at abeyance and postponed pending the outcome of Mr. McIntyre's trial, she went out and obtained criminal conviction for the felony offense of credit card and debit card abuse. She was also arrested and charged with unlawful carry of a weapon. That case was dismissed because she pled to a different offense. We've included all of those records that we've obtained from the Harris County clerk as exhibits in the motion for new trial, which we'd ask that the court receive. We also made a bill of exception at the trial of the judgment of conviction for credit card and debit card abuse at the sentencing phase of the trial, which we'd ask the court to take under consideration as well. There's just no question that the state told the jury something that isn't true. Now, listen, I think Jason Garahan is a very reputable, honest, and hardworking prosecutor, and I have immense respect for him. I don't know why they said this, but it's just not true. It's objectively false.
All right, response.
Well, Your Honor, with respect to the statement, I trust that their motion states what I said during argument, which is closing argument during the guilt innocence. And what it may be, slip of the tongue, or the fact that I misstated that Joanna Reyes had I don't know exactly what was said, but alluded to the fact that she didn't break her bond is something that can be argued, that it was done by mistake on my part. That may be, but the fact remains is that the defense counsel knew about this and did not bring this up during her cross-examination. And the fact is that the jury is well aware of her credibility or credibility issues, if you may, of her being a co-defendant to a capital murder and of her testimony that she gave during the portion of guilt innocence. And touching on the subject of the prior judgment, defense had every opportunity to recall Joanna Reyes onto the stand during punishments, which they chose not to do. And, if they consider our duty or their duty, the fact is that their client was the one that was facing 5 to 99 years of life. And they could have called back Joanna Reyes and questioned her on the subject, and they chose not to. That fact does remain there, Judge. So that's the state's position on it.
Judge, just one more thing. Closing arguments are just that, arguments. They're not evidence. And the jury was instructed about that multiple times. And so that would just be another argument regarding that.
All right. With regards to point 2, the motion for new trial will be denied with regards to point 2. All right. Thank you.
May I be excused, Your Honor?
Yes.
I guess, well, we don't need the other. I'll be filing an amended notice of appeal to include the denial of the motion for retrial.
Sure.